Welcome to NIPT's Decisions on the Go, using AI for over a decade to help you listen to New York State Court of Appeals decisions on the go. After the podcast, visit www.nipt.com/law to read the full decision.
People v. Jalen Wiggins, decided on November 25, 2025. Garcia, J. On this appeal, we are asked to determine whether the trial court abused its discretion by refusing defense counsel's request for a mistrial after the court inquired into a juror's allegations that racial bias had been displayed by other jurors. On this record, we hold that the trial judge did not abuse his discretion in denying that request, and we therefore affirm. Two separate shootings involving 4 victims occurred in Buffalo in the early morning hours of August 4, 2016. The first took place at approximately 1 a.m. in the vicinity of Maple Street, where the victim was shot and wounded. Approximately 1 hour later, in the vicinity of Sherman Street, a second shooting occurred that left 1 dead and 2 others injured. Defendant was indicted on charges related to both shootings, and the case went to trial. The distinctive clothing worn by the shooter in both incidents became key evidence in the prosecution's case. Several witnesses described the shooter at both locations as dressed in a cream-colored or beige shirt with a Burberry-type plaid pattern and white pants. Surveillance video from the Sherman Street location showed 3 individuals firing weapons, but as the witness who described the video while it was being played for the jury noted, it was not possible to make out the faces of the assailants. It was, however, possible to see that the shooter positioned closest to the victim was wearing white pants and a light-colored plaid shirt. A surveillance video from Buffalo City Court showed defendant approximately 12 hours prior to the shootings wearing the same light-colored shirt with a Burberry-type plaid pattern and white pants. Testimony of a firearms examiner and the medical examiner linked the gun used to fire the fatal shot at Sherman Street to the person wearing the white pants and light-colored shirt in the video. A surveillance video from Buffalo City Court showed defendant approximately 12 hours prior to the shootings wearing the same light-colored shirt with a Burberry-type plaid pattern and white pants. Testimony of a firearms examiner and the medical examiner linked the gun used to fire the fatal shot at Sherman Street to the person wearing the white pants and light-colored shirt in the video. After deliberations began, a note from Juror 5 to the trial judge raised, among other issues, the allegation that a certain other juror, later identified as Juror 10, had displayed racial bias during deliberations. In response, the trial court individually questioned Jurors 5 and 10, afforded counsel the opportunity to inquire, and thereafter denied defense counsel's motion for a mistrial. The jury found defendant guilty of murder in the 2nd degree, assault in the 1st degree, and criminal possession of a weapon in the 2nd degree, and acquitted him of 2 counts of attempted murder. Defendant moved pursuant to CPL 330.30 to set aside the verdict based on Juror 5's allegations of racial bias. The court denied the motion, holding that Juror 10 denied making the remark in question and offered an explanation for the remark that was actually made and the possibility that the offended juror might have misinterpreted what was said. In addition, the court expressly noted that the defense did not request that either juror be removed and substituted by one of the alternate jurors. On appeal, the appellate division held that the trial judge did not abuse his discretion in denying a mistrial because the court made an appropriate inquiry into this most serious charge of racial bias by consulting with the parties and questioning relevant jurors, which ensured that defendant's right to an impartial verdict was properly balanced with the jury's right to adjudicate free from outside interference. In reviewing the actions of the trial judge, the court concluded that, in a probing and tactful inquiry, the trial court did evaluate the nature of what Juror No. 5 had seen, heard, or had acquired knowledge of, and assessed its importance and its bearing on the case, quoting People v. Buford. 2 justices dissented, asserting they were unable to conclude on the record before us that the jury was not tainted by racial bias in their deliberations. A dissenting justice granted leave to appeal to this court. 2. This court has long recognized that allegations of racial bias by a juror raise issues that go to the heart of a defendant's right to a fair trial. See e.g. People v. Leonti. Uncontroverted evidence of ethnic bias expressed by juror required reversal. Among the several safeguards in place to protect that right under CPL 270.351, if at any time after the trial jury has been sworn and before the rendition of its verdict, the court finds, from facts unknown at the time of the selection of the jury, that a juror is grossly unqualified to serve, the court must discharge such juror and must declare a mistrial if no alternate juror is available. People v. Spencer, quoting CPL 270.351. A juror is grossly unqualified in this context only when it becomes obvious that a particular juror possesses a state of mind which would prevent the rendering of an impartial verdict, quoting Buford. This means for a sitting juror to be disqualified, the record must convincingly demonstrate that they cannot render an impartial verdict. A trial court must be vigilant in investigating such allegations. See Buford. When presented with some credible information indicating that a sworn juror may be grossly unqualified, a court must conduct a probing and tactful inquiry of the juror, Kudzal. We have also cautioned that it would be unnecessary and indeed inappropriate to subject a juror to questions relating to her thought processes, the deliberations, or other matters that lie within the confines of the jury room. People v. Sanchez. As these guidelines make clear, a trial judge's investigation of juror misconduct or bias is a delicate and complex task, and courts must have broad flexibility in matters involving the jury. We therefore review a trial judge's decision concerning allegations of juror misconduct for abuse of discretion because the trial judge, having the ability to continually observe the jury in court, is in the best position to devise an appropriate remedy. Defendant did not challenge the procedure followed by the trial court in questioning the 2 jurors and never asserted that the questioning failed to meet the careful and tactful inquiry this court requires, but rather claimed only that a mistrial was warranted after this inquiry was done. It is important to place the trial court's actions in response to the allegations of racial bias in the context of the trial judge's experience with this jury. Those allegations came to the court's attention from Juror 5, who had earlier been accused by defense counsel of sleeping during the court's jury instructions. Juror 5 was questioned and denied sleeping, stating, "No, I nodded once. I was listening to you with my eyes closed. I heard you." After Juror 5 returned to the jury room, defense counsel, who had initially requested that Juror 5 be replaced by an alternate juror, said she was satisfied and consented to allow Juror 5 to continue to serve. This same juror then made an allegation of racial bias in a handwritten note sent directly to the trial judge without the foreperson's signature in violation of the court's instructions to the jury. The note read, "Your Honor, I would like to see the video with the 3 men running to the car on Sherman Street. Also, I would like to hear the 2 closing arguments again. The other jurors do not to see or hear the evidence again. I was told the video would not show anything better. For me, I would like the screen more centered on the middle. I was told on Friday that all black people look the same in the dark. That's insulting to me. I do not want to be bullied into rushing my decision. 2. On Wednesday, a person listening to the trial kept trying to get my attention. He kept squirming in his seat. I ignored him, then I looked him in the eyes. He did it in the morning and the afternoon. Also, the female assistant DA began smiling. It looked like an approval of her partner's statement Wednesday. It could make the jurors feel it is a win for the people. An officer in your court patted a city officer after the testimony. Need more stoic environment. I asked to see you on Wednesday, but I was not given instructions. P.S. I had taken a non-drowsy over-the-counter drug. I found it was not manufactured in the USA. I bought it from Dollar Tree. The parties and the court agreed that the note was improper and that the jury should again be instructed that any communication had to be signed by the foreperson. The court did so, and a short time later the court received another note, this time properly signed by the foreperson and initialed by Juror 5. The note asked for certain evidence and included a statement that, "I'm not going to call into question man staring at me from gallery all day Wednesday." Another juror noticed he moved in his chair to make sure I saw him. There was no mention in this note of the earlier allegation of racial bias. Nevertheless, defense counsel now raised that issue for the first time, claiming that she merely wanted the court to note our exception to the fact there may be evidence of racial bias in our jury. The court, however, insisted that the issue needed to be promptly addressed by bringing out juror number 5 to find out which juror allegedly said what she put in that note and then ask that juror about it. The parties agreed to the trial court's plan, with both parties requesting only that the inquiry avoid delving into the substance of jury deliberations. The trial court's subsequent inquiry of the two jurors was tactful and at the same time avoided improperly intruding into the ongoing jury deliberations. The court first confirmed with Juror 5 that the comment concerning race was made during deliberations, and then had Juror 5 identify Juror 10 as the one who made it. In a somewhat confused narrative, Juror 5 then spoke at length about the person allegedly staring at her in the courtroom, and claimed that Juror 10, the juror she alleged made the offending comment, noticed it as well. The trial court afforded both parties the opportunity to inquire. The prosecutor asked Juror 5 if anything about the comment or her belief that someone was staring at her would prevent her from continuing to be a fair and impartial juror in the case, and Juror 5 answered no. Defense counsel asked, have there been other jurors in this panel who have expressed the same sort of insulting bigotry? Juror 5 answered yes, and stated that it was a common thing and I told them today I didn't appreciate it, but she didn't know how far she wanted to go into an individual person because she didn't know their names. In response to a question from defense counsel about how many of our white trial jurors have expressed this bigotry during the process, Juror 5 responded, I would say approximately 6. Juror 5 explained that other jurors had made statements as though blacks are different than white people, and she described it as an insult to categorize everybody into this gang crime-related thing. When asked to identify the jurors who had allegedly expressed bigotry, Juror 5 responded they changed their mind today and that they had apologized for their statements. Defense counsel asked for reassurance that the racial animus you experienced has been extinguished, and Juror 5 responded, I don't know if it's been extinguished. I cannot guarantee it, but they're aware of it and are looking more deeper into the trial than which they would have on Friday. Juror 5 added a vague reference to some type of age bias, noting that today was said by a younger person in the group. That's the trouble. They say, I took psychology and sociology, and they say, the trouble is you don't want these older people as jurors because they always have a benefit of the doubt kind of thought. Juror 5 added a vague reference to some type of age bias, noting that today was said by a younger person in the group. That's the trouble. They say, I took psychology and sociology. And they say, the trouble is you don't want these older people as jurors because they always have a benefit of the doubt kind of thought. After this inquiry, without any questioning of Juror 10, defense counsel moved for a mistrial on the grounds that the panel was impermissibly tainted with racial bias, and argued that at least 6 of the other jurors were incompetent to serve based on these allegations alone. Defense counsel declined to have other jurors questioned, saying it would be impossible and that it wouldn't fix anything, and the only thing that would fix it is if we have a mistrial and can start over again. The trial court instead adhered to its earlier decision to question the juror who allegedly made the offending comment, now identified as Juror 10. The court asked Juror 10 if she had in fact said that all black people look the same in the dark. She answered, I didn't make it in that way, explaining that she had mentioned her Asian daughter and that you can't make an accusation on someone based only on looks. When asked if other jurors had expressed the same sentiment, she responded, I don't think so, adding that things were trying to be rushed on Friday and that more time was needed. When the court pressed whether such racist sentiments were expressed in the jury room, she answered, no, not in that manner. She also responded yes when asked by the prosecutor if she could continue as a fair and impartial juror in this case. When invited to question the juror, defense counsel asked how the topic came up. Juror 10 stated that another juror wanted to see the video again, and that she responded, you can't see anything on the video because it was both taken at night and grainy. As a result, the discussion in the jury room focused on clothing rather than faces. Defense counsel confronted Juror 10 on the issue of racial bias and whether a discussion surfaced about racial bias, and Juror 10 answered no. Defense counsel asked, something that would smack of racial prejudice? Juror 10 again responded with a definitive no, adding that the only thing I said was about my daughter. I would hate to be there and somebody accusing my daughter of something and they can't see her. After Juror 10 was questioned, defense counsel again moved for a mistrial, requesting only that one remedy after having made clear that she did not want the other jurors questioned. Nor did she request that an alternate replace Juror 5 or Juror 10, although alternates remained available at this point in the trial. As the appellate division noted, the trial judge was effectively tasked with determining whether the answers elicited from the jurors provided evidence of racial bias potentially affecting jury deliberations or, instead, supported the conclusion that, following an initial rushed session, there was a frank discussion among the jurors about racial bias and the appearance thereof that prompted a closer look at the evidence. The mere fact that race entered the jury's deliberations does not establish that racial bias infected their verdict. Jurors discussing identification evidence, particularly the difficulty of identifying individuals in nighttime black and white video footage, may necessarily touch upon physical characteristics, including race, without harboring or expressing racial animus. Here, the record indicates that the discussion at issue arose in the specific context of evaluating the crime scene surveillance video and whether the grainy nighttime footage could support any identification beyond linking the shooter's distinctive clothing to defendant. Here, the judge was aware of the conduct of the jurors throughout the proceedings, observed the demeanor of the jurors as they were questioned on the issue of racial bias, evaluated their responses, and reasonably concluded on this record that what Juror 5 perceived as racial bias was in fact a discussion about the identification evidence, some of which, as the court noted in its post-trial decision denying the motion to set aside the verdict, may have been misinterpreted. As to the other unidentified jurors allegedly harboring some form of racial bias, defense counsel declined to request that the court question them individually and, indeed, argued that the court should not do so, and therefore, the only asserted error preserved for appellate review was the denial of the motion for a mistrial, People v. Bailey. Our role is not to substitute our judgment as to the appropriate remedy for that of the trial judge, nor, as our dissenting colleague would have it, was it Juror 5's role to guarantee the defendant a fair trial. On review of the record here, we hold that there was no abuse of discretion in the trial court's denial of the motion for a mistrial. Defendant's remaining arguments do not warrant reversal. His argument that the trial court erred by not reading the complete jury note into the record is unpreserved, see People v. Mack, as is his argument that Juror 5 was grossly unqualified to serve because she was asleep during the court's jury instructions. Finally, the Appellate Division applied the correct legal standard in conducting its weight of the evidence analysis, and therefore that holding is beyond our power to review, see People v. Concharla. Accordingly, the order of the Appellate Division should be affirmed. Order affirmed. Opinion by Judge Garcia. Chief Judge Wilson and Judges Singas, Canataro, Troutman, and Holligan concur. Judge Rivera dissents in an opinion. Decided, November 25, 2025.
Welcome to NYPT's Decisions on the Go, using AI for over a decade to help you listen to New York State Court of Appeals decisions on the go. After the podcast, visit www.nypt.com/law to read the full decision.